Okay, well, I'm going to go ahead and start. Thank you all for coming to another session of CCDC's Lunch and Learn. This training session is specifically regarding drop-in swaps. And we have, luckily, our attorney, Steve Umaña, who's going to go through the whole presentation, and then Juan will give you some more, color as to that next. But a couple of housekeeping things. Restrooms are out the door to your right and around if you need to use the restroom. We're going to leave one of the doors open. If you want to go back out and get more food and drink, feel free to do that. I think Steve wants a fairly robust conversation, so if you have questions throughout the presentation, don't be afraid to just shout them out, say whatever. Also, we are taping this seminar because we want to put it up on our website for those people that couldn't attend today. So they will have the same information. So if you have a question, I'm sorry? Oh.
I got him in trouble.
Okay. But if you are going to ask a question, just make sure you say it loudly. Steve's going to go ahead and repeat the question so it gets captured on the presentation. So in that, thanks again for coming. I'm going to introduce Quan Chan to give you some more information.
Yeah, so a lot of familiar faces, but I'm Quan Chan. I'm one of the lenders here at CCDC. But I'll really just let Steve kind of introduce himself. But I had the opportunity to work with Steve on a transaction last year where he had represented one of our borrowers on a 504 loan transaction that was on a real estate purchase. And I think this topic has just come up more and more frequently, especially over these past couple of years. I think I've talked through maybe a dozen of them just in the past year. And Steve was just really able to kind of like dumb it down for me last year on this transaction. And, I thought that, wow, this is like very insightful. It's great. And I'm glad that you guys can all join. So I'll just go ahead and turn it over to you and get started. And
thanks for the kind words, Quan. Hey, everybody. Steve Umaña. I'm a lawyer over at Kegler Brown Hill Ritter. I do real estate and finance. Practice is sort of threefold: commercial real estate, purchase, sale, development, and then bank finance, whether it's asset collateralized, real estate collateralized, represent banks, represent borrowers, and then do low-income housing, tax credit, HUD work. So I couldn't echo what you said more. If you have a question, ask a lawyer. I'll be accessible. Today, though, we're going to talk about drop-in swaps, which I'm sure you've heard the moniker drop-in swap. What is a drop-in swap? It's a nickname for a membership interest assignment. And throughout the last decade or so, it's become increasingly popular as a way to potentially minimize property tax liability. That's really what you'd think of as a quote-unquote drop-in swap. There's other situations and times when membership interest assignments are employed as it relates to real estate. You have your mergers and acquisitions transactions where there's roll-ups into a single entity. There's personal residence situations where you're buying a really expensive home cash, and you put it in an LLC to avoid, possible revaluation on that purchase price. You can buy an LLC. If you find a building that you like and you don't want a deed to be recorded at all, you could buy an LLC. There's other considerations there, but the conveyance of real property can take a couple different forms, and this really sort of is one of them. In the banking world, there's a few things I think to remember. At the end of the day, your mortgage lien stays the same. There's no difference in your collateral, which I think is a point that, when we discussed, when you were asking, what does this mean for my bank? Well, it means a couple things in underwriting. Number one, you need to figure it out sooner rather than later. Some banks have an internal policy. If it doesn't fit in the box, you can't do it. And, some of the larger banks I've heard of doing that. But, sometimes organizational documents won't get signed until closing, which can throw underwriting. Maybe you won't have an EIN as early as you would have if you were just assigning the purchase contract to an LLC to buy it, with a straight deed conveyance for consideration. So some of those things you want to get out ahead of. But as far as due diligence goes, the title policy, the survey, the phase 1 zoning report, all that goes in the name of your borrower. So why don't we go ahead and Okay, so this is kind of what we're going to hit. I kept it light. I'm hoping for some questions, but we'll go through the steps and sort of the perceived advantages or why people are doing them. There's been changes in legislation. There's currently legislation in the Supreme Court. We won't go too far down the weeds into the current legislation, more high level overview of what's happened in terms of the history and where we're at now. But it's an ever-changing beast, and there's rumblings, that I don't know if they have legs about getting rid of property tax. So it's definitely something that, you're hearing more and more. So you have your drop and swaps, which would be, the prepackaged sort of membership interest transfer. LLC purchases, whether it's just a straight LLC conveyance, or maybe you split real property and assets up and do it a different way. And then, what does this mean for due diligence? What is the general due diligence? This can go a little broader than just drop and swaps, but how does this play in with sort of what I talked about, your mortgage lien, your underwriting? What do you need to worry about? And then just general question and answer on anything related to this topic, or stuff, purchase, sale, real estate, or finance. Okay, so the steps. Every lawyer can do these a little bit differently. I've developed the way that I've done it and, maintain that strategy. So the first thing you need to do is make sure the parties agree, right? You have your buyer and seller. They're going to sign a purchase contract. Sometimes you will have a one sentence blurb in there that says buyer and seller agree to do a drop and swap. And that's fine. It's an agreement. It's a legal agreement. There's no agreement as to how that actually occurs. So I've seen it, I've gotten a contract on the CBA forum that has a one-liner that says, we agree to do a drop and swap. I've also had purchase contracts that we've drafted where there's an entire section that goes through the mechanics of it, the steps of it, when a party gets to elect, and so forth. So I represent buyers and I represent sellers, and there's, we'll sort of get this to the advantages, but you want to flesh this out on the front end. You guys are on the banking side, but just when you're looking to do some sort of acquisition, you want to talk about this now. If there's not an agreement, sometimes the seller could refuse, or the buyer could refuse if the seller wants it. So usually my practice is sort of a short and sweet paragraph that, outlines that either party, or maybe just the buyer, has the election to consummate closing via a membership interest transfer. I don't normally attach the actual documents to the PSA to say, like, this is how we're going to do it. I usually just say it's up to mutually acceptable agreements to keep the PSA a little shorter. But like I said, it can go down to the nuts and bolts of the steps and timing and what needs to happen. It can get as complicated as you want to make it. And so it doesn't matter if it's not in your contract and the parties later agree to do it. We can always do an amendment to the contract. Most lenders will want to see this, from what I understand from working with folks like yourself. You want to have an agreement, right? You don't want to base your underwriting and march toward closing only to have the seller say, I'm not doing this, I don't feel right about doing it. So you really do want it in your purchase contract. You need to have an obligation to do it. You can always handle it informally if it's not in there and the buyer says, I want to do a drop and swap, and the seller says, okay, then okay, there you go. But you run a risk without having it documented and abided to. Yeah.
So you mentioned a couple times about a seller maybe not being comfortable with it.
Yeah.
So you mentioned it twice, so I'm figuring it might be common.
What
would they object to? What would be?
That's a great question. So there's been controversy around this topic, right? I mean, folks have differing opinions. This is sort of a bigger global theme, really, of it. But is this okay? Is this right? Is this legal? Are you going to get in trouble? So that's really important to think about on the front end. So the way that we sort of approach this, and the way that most of our clients approach it, is it's similar to maximizing deductions on your tax return. There's no law against it. There's nothing that you're signing necessarily that's explicitly putting you in perjury. Now, I've seen real property lawyer listservs debate nuances of the drop and swap, and whether does the LLC purpose clause get violated or what have you. Bottom line is they're pretty still widely employed. And there's other states like Michigan that have a box on the conveyance form that says, is this a membership interest transfer? And if you don't check it, and it is, you've committed perjury. That would be very easy for Ohio to do, I think. It hasn't happened. So whether that's the will of the legislature, the people, or what have you, or we have a pretty friendly business economy too. That's some of it. And you're seeing, like I said, the legislation go to the Supreme Court, and you have law firms that are championing these processes, that have cornered the market on representing school boards. So, going back to, is this right? Personally and professionally, we recommend it as a way to potentially minimize property taxes. What happens if the auditor finds out? Well, two things. There's two benefits. We're kind of skipping ahead, but there's two benefits. One's on the buyer side, the property not being revalued at the purchase price. The other side's on the seller side. They get to save on the conveyance fee. So sometimes when I'm representing sellers, I say, let's do a drop and swap. Let's save $5,000. Clients love that. Very often do I get to save my clients money, that sometimes is automatic for the seller, but people can get cagey on it. I mean, I've had people that say, why are we forming this LLC? I don't know what the tax ramifications will be. I'm used to doing it this other way. I don't want to do it. It's not a given, right? In your normal purchase contract, a seller is required to produce a deed, not go through the extra steps sort of the drop and swap. So you'll have people who will think that they're going to get in trouble. And we'll get into that, sort of later. But it's good to spell out, kind of what the general plan will be in the purchase contract, so there's no surprises. Okay, so typical real estate deal that you guys are working on, you get into a contract, and usually it's not the title holding LLC or the borrower, right? So we're going along inspection, probably want to get through inspection to form the LLC, so you don't have an LLC that's sitting out there and you kill a deal. And then those documents start to get sent to underwriting. Usually you can form that LLC and go all the way through, right? Articles, operating agreement, EIN. You have everything you need for underwriting. Easy, there you go. Drop and swaps are going to be different. It's similar theory if you don't want to do all this, and then kill the deal for a bad boiler or something. So but it's even worse for you guys because you wait a little bit longer and things don't necessarily get signed. So in terms of the documentation, I don't want to trivialize it, but the way I try to explain it to my clients is it's a regular real estate deal with a couple extra pieces of paper. And that's how it functions with the title company. Frankly, that's how it functions with funding and mortgage liens. It's a regular real estate deal with a couple extra pieces of paper. Typically in commercial real estate deals, you can pre-sign stuff and you put it all in escrow and you date it and everybody holds it, and then you get to closing and hopefully you wake up on the morning of closing and everybody sends an email that says congratulations. That's what we all dream of. And I'm sure that happens on 100% of deals for everybody, where you just wake up and close. Same thing here. So when you're on the underwriting and financing side, you're going to probably end up looking at a draft of the ultimate borrower operating agreement. So typical organizational and authority documentation of sort of how I frame it in my mind for an LLC, you file your articles. That's easy. Ohio's great. Articles are $99. There's no annual fee. And if you have a lawyer do it, they usually just act as your statutory agent for the life of the LLC, which unless you dissolve it, is forever. Much different in Delaware, California, New York, you're paying an annual fee. It changes the game on forming LLCs. I have clients who have 6 or 7 unused LLCs, and they have a deal come up and they say, okay, let's pay $25 and change the name to whatever. And then they have somewhat of a seasoned LLC, which, can be beneficial for some, underwriting and financing purposes. So you have your articles. Now the seller is going to be the sole member of the LLC. So your articles are filed on, let's just say, July 10th. That's going to be the effective date of the articles of organization. Those, if you have them filed by a law firm, which I I'm a lawyer. Of course, I'm going to recommend it. But then you don't have to put your name all over it, right? There's nothing worse than buying a duplex and doing the LLC yourself, and then the tenant goes on the Ohio Secretary of State's website, sees your name and your address. I mean, you're still shielding yourself from personal liability, but you're not at all protecting your identity. And it's most of the time when you get stuff that means anything to your statutory agent address, it's when you're getting sued. So it's always good if your lawyer gets that first. Anyway, shameless plug. So you got your articles. The seller is going to be a sole member LLC, right? But the buyer usually takes charge of this because this is ultimately the buyer's entity. So I, as buyer's counsel, or if I'm seller's counsel and I'm kind of driving the ship, I'll form the articles. Our firm will act as statutory agent. Then you'll have an operating agreement. It'll be typically a sole member operating agreement. Very short, simple form. For tax purposes, it's a disregarded entity. The operating agreement effective date will be the effective date of the articles, so there's no sort of gap of forming an LLC and not knowing who owns it. So then, you have your operating agreement. It's dated July 10th, and the seller's the sole member. So then you started the process there. Seller doesn't sign it. Go ahead.
So if you're buying an older LLC, you have to backdate the new operating agreement?
Good question. So if you're buying an older LLC, then you're not doing a drop and swap. Then you're doing a purchase of membership interest, and you need, I wouldn't want to say significant, but a lot more in your purchase contract because you have an operating company. That operating company could have been going around and stiffing every contractor in town and could have been not doing withholding. So membership and pure membership interest purposes are way more efficient at mitigating your property tax liability because there's no deed and it's the Wild West. No one ever knows. If this building is owned in an LLC, the owners could just sign a one-page assignment and there you go. Now they'd violate every loan covenant in their financing and there'd be other problems, but it wouldn't have to go through the recorder. It wouldn't, and when it goes to the recorder, it goes through a slew of processes. You have your deed transfer office, you have your engineer's office, you got your recorder's office. So just a regular LLC purchase, and in that situation, you wouldn't backdate it. In that situation, you would, you would very much hope there's an existing operating agreement that evidences current ownership. And then you would take an assignment in whatever form. Yeah. And then you'd amend and restate yours. That's what I would probably advise in that situation. But if you're looking at just a pure membership interest purchase, Spidey sense needs to go up a lot more than just a drop and swap. Drop and swap, regular real estate deal, couple extra pieces of paper. Membership interest purchase, if it's just for real estate purposes, and that's its only asset, it's not just a regular real estate deal. But if it's other things, then it's just a pure asset acquisition with a real estate component. And that's where you see it get real complicated, where you have, a conglomerate that owns a couple different companies or properties and they roll them up. And so going back to your question, is it wrong? Is it right? Well, a huge dollar amount mergers and acquisitions, they're doing all types of exempt conveyances and maximizing property tax liability. They're not thinking twice about it. And they're doing that on every other part of their deal. So, yeah.
$1 million to $5 million deal. What are you quoting your client to do?
Yeah, so that's a good question. So I usually tell people, the decision of whether to do this is a business decision. This is my favorite way to push back on you. But, if it's worth spending an extra $1,200, $1,250 in legal fees, filing fees, assuming you don't get a big fight with documents, if that expense is worth the potential of mitigating X, do it. And we'll get to, it's not foolproof, right? We'll get to how that works a little bit later. But yeah, $1,000, $1,200, $1,500 maybe. Some people have more questions or want to really, really go through it. Other people say, give me the document package and there you go. So you start off and you get through inspection, and this is the point where your lender's saying, I really need some more docs. I can't be ready for my clear to close. I don't have an EIN. Okay, well, now we're ready to do the drop and swap. So we'll file our articles. We'll prepare the documents. We won't sign them. So my typical drop and swap document package will be articles of organization, It'll be an operating agreement that evidences the seller as the sole member. It'll be an authorizing resolution that the title company requires. I'll date that, the date of closing, and I'll have the buyer sign that, because as of that date, the buyer is the owner of the LLC. There's a ratification provision. Again, every lawyer might do it a little bit differently. The general structure is the same. And then you'll prepare your conveyance docs. And we'll get to that on the next slide. But when you get to closing, you'll amend and restate the operating agreement. So if you're looking at a package in terms of Oregon authority for underwriting, you probably should have the articles, an unsigned operating agreement, and an unsigned first amended and restated operating agreement. You can get the EIN now. I typically will, because banks need it. As I would have the buyer do it, because ultimately the buyer's going to be the one with the LLC. So, there's this whole second step, right? Of, well, what's the ramifications of the seller owning this LLC for an indeterminate number of time? Well, there's no income, first of all, and it doesn't own anything. The way these deals work is everything gets signed and delivered in escrow. Dates are staggered. Funding, let's consummate closing. Now it's all effective, right? So if the deal never happens, the sole member operating agreement is never really signed. You could then make an argument in court, well, even though there's no evidence of ownership, seller, that was yours. Well, there's not much there if the deal doesn't go forward. Some people will have an issue with that. What does having an LLC formed and out there do? And they won't be willing to do that for whatever reason. It just can feel wrong. But at the end of the day, your borrower will have articles and a first amended state operating agreement, which will show your borrower as a sole member. You'll have a resolution signed by the borrower, for the LLC that authorizes the loan, authorizes the purchase, authorizes the assignment. Title company will accept those docs as they would for any other buyer. And you'll go forward with the conveyance. So like I said, Ohio has good, cheap LLC laws. Hopefully that never changes. But in other states, it's annual fees and a much higher fee to file. Okay, so sorry, it's 4 steps, but I think of it as 3. Purchase agreement, step 1. So you got your second step, which is your first step of actually doing it. Right? Seller forms sole member LLC. Step 2, seller transfers the real estate, any personal property, any leases, maybe other valuable agreements to that LLC. And that is done as an exempt conveyance for the real estate. There's 2 ways to convey real property via deed. I guess as you're going sort of through the auditor process. One is just a straight conveyance, and the other is an exempt conveyance. An exempt conveyance means it's exempt from the real property conveyance fee, which every county is different. It's multiples of 1,000, so take the purchase price divided by 1,000 times $4 for Delaware, I think. So that fee is triggered when you have consideration or a purchase, sale, a regular deal. The exempt conveyance form has several exemptions, got to be 15 to 20, for different situations where that conveyance fee wouldn't apply, or where money's not really changing hands. There's exemptions on there to and from government, instrumentalities, or to and from nonprofits, or father to son, or spouse to spouse, or there's different situations where you got to file a deed and you're not buying real estate. And that's what they're trying to figure out. They're trying to figure out, what is the market saying this real estate is worth? And the market is your purchase price, just like the market would be for any sort of other asset that's sold back and forth. So, the exempt conveyance form has a lot of good stuff in there. If you have a weird situation where, there's maybe a inter-family transfer, or maybe it's not a drop and swap. M gets used all the time when I have clients that buy a property in their own name. Some of them may have done that for more favorable loan terms, and then they put it in an LLC. may violate the due on sale clause. But M's, really readily used for that. So a lot of business reorganization, happens with M. So the deed, the real estate conveyance package, will go from 3 forms to 2. So you have a deed, exempt conveyance form, and an affidavit of facts. These can work in a variety of different capacities. It doesn't just have to be a drop and swap. Say I own 4 LLCs say me and my brother and my sister own an LLC, and that owns a bunch of other little LLCs, and those each own property. And I want to deed all those properties from all these little baby LLCs to this other LLC that me and my brother and sister own outright. That counts. The trick is the language in the exemption, right? And it's kind of weirdly worded, but it's to or from a person when no money or other valuable, tangible consideration readily convertible into money is paid or to be paid for the real estate, and it's not a gift. What does that really mean, right? I'm not going to try to unpack the drafter's, language and putting it like that, but you can't have consideration. Same example, I own a property with my 3 siblings in an LLC, and I transfer it just to me and my brother. Well, me and my brother just received something of value. Instead of a third, we have a half. That's a situation where M wouldn't work. So your affidavit of facts, there's always like the magic words that the auditor will look for. Estate planning purposes, reorganization of assets. Those are the things that they're not going to try to hold up, right? I mean, they don't care. They want you to protect yourself from personal liability. They want LLCs to own rental properties and transact business like that. So, that happens all the time. So you can be creative. I mean, I have situations just like that, and there's other times where you have a really weird situation where maybe there's a limited partnership and people are getting distributions, and maybe somebody is getting the benefit of this, but someone else is getting a distribution there, and you can get all this pre-approved. So drop and swaps, we've done a million of them. Other exempt conveyances, if I'm doing it in a unique situation, we call the auditor, we send our documents down there and send, can you approve the exempt nature of this transaction? And they email back and say, this is approved. Save that in your file, and what does it do? I'm not going to sue the auditor, but it at least gives me the peace of mind that I'm not going to get to recording and all of a sudden, oh no, you need a conveyance fee, the deal's held up, the loan has to go back because we hit a cliff or whatever. So all these things, deeds, legal descriptions, exempt nature of conveyances, you can all get them pre-approved. Now I would, if you're ever in that situation, I'd highly recommend doing it. So yeah.
Does that fall to the bank or the borrower?
Borrower. In the transaction, the bank in document-wise comes in at your mortgage. And that mortgage will be recorded right after the deed. So as far as you're concerned, the title company needs to produce a recordable legal description and a loan commitment, and will insure your mortgage lien as a first priority mortgage lien. Whatever happens, drop and swap, that's not really the bank's problem. That's a couple things, to remember. First position mortgage lien, at the end of the day, when the loan is funded, the same effective date as your loan agreement, your note, whatever, the borrower will own the borrower LLC. So it's tough procedurally because you're not going to ever get your everything cleared before you hit closing because you don't know if you're going to close. So again, we throw everything in escrow. People love to pre-sign. Now you can e-sign. You can't e-sign a deed or an affidavit. You can e-sign everything else. You can e-sign a deed and get it e-notarized. That's where I get a little old school and I'm like, no, let's just do it the regular way. I don't know why. I mean, it's valid. You can do it. I work with lawyers that do it all the time, but I still will have people, manually sign a deed and stamp it and get the original. We e-record though, which is nice. So, okay. So then you go into closing. At this point, all your docs are prepared. The bank should have what they need. They should have title. showing the title holding LLC as the proposed owner, the bank as the insured, all the endorsements, all that's valid, modified from the drop and swap, mortgage location survey, Alta survey, whatever you need, same deal. All listing the bank and the title holding LLC and their certifications, environmental, phase 1, zoning, whatever, SIVO, anything that you need. And all your documents are prepared and signature pages are distributed, right? So, you'll split those up. You'll get the title company to, throw in affidavits and whatever FERPTA certifications they need. And you'll get those signed and everybody will overnight it. And in a perfect world, the eve of closing or the morning, if you're an afternoon closer, title company will circulate all the docs and they'll circulate the articles. They'll circulate the operating agreement, which is now signed, has a signature page affixed to it. That operating agreement is dated, let's call it July 11th. Then they'll circulate a fully signed, notarized, executed copy of the deed, which I always date it one day before closing. That way there's no question. Some lawyers will date the deed and the assignment of membership interest the same day of closing. I like to stagger it. So, it's really 3 days. Day 1, seller forms sole member LLC. Day 2, seller conveys real estate, personal property leases to LLC via exempt conveyance. Day 3, buyer buys LLC. That's the day of closing. I like doing that. It just makes, there's some degrees of separation. So they'll circulate the fully signed deed, affidavit, an exempt conveyance form. They'll have the resolution from the borrower. And then we'll also get the first amended and restated operating agreement signed by the buyer, circulated, and then the assignment of the membership interest. And so that document will be dated as of our closing date, along with the first amended and restated operating agreement. So 3 days. Day 1, seller forms LLC, of which seller is sole member. Day 2, seller gives the real estate, personal property, all the assets to the LLC. That's an exempt conveyance. No money has changed hands between the seller and the seller's LLC. You can sign that exempt conveyance form. You're not lying. That's true.